welcome to the VSS Hour. As always, my name is Vanessa Joseph.
And my name is Shirley Planton.
And my name is Sandra Dennis.
And we are here today with the very, very first episode of our brand new segment, Beyond the Hour. Et ça nous essaie fait, c'est parler plus sur différents sujets que nous pensons extrêmement importants pour la communauté, mais qui ne pas carré tant que dimanche vini. Donc, c'est pour ça que jeudi, bon, à soir, nous venons avec segment ça, et pour la première fois, nous avons le premier guest nous là. And we want to welcome him to the VSS Hour, Mr. Anthony Georges-Pierre.
Bonsoir tout le monde.
Et je dis, nous allons parler sur qui doit que yon employé ou bien penser que yon ancien employé yon travail gagné, surtout dans le coronavirus. I think that we all know different folks who are affected by the coronavirus in the way that it takes away opportunities for employment. Some folks are being laid off, furloughed, outright fired, and things like that. So, you know, the ladies and I thought that it was extremely important that we bring conversations like this to the forefront. And so, Anthony, I think we'll give you an opportunity to introduce yourself, and then the ladies will get started with questions right after that.
Great. Again, like I said earlier, thank you very much for having me on your show, VSS ladies. My name is Anthony Georges-Pierre. I'm an attorney with the law offices of Reamer and Georges-Pierre. Encore merci beaucoup pour l'opportunité ça que au moins pour me venir parler avec moun yo k'ap koute suivre programme nan. C'est avocat Anthony Georges-Pierre du cabinet Reamer avec Georges-Pierre. Nous concentrons comme avocat dans le droit de représenter moun qui dans travail, qui a un problème dans le travail, avec moun qui est endommagé. Aujourd'hui, nous invitons pour parler sur l'affaire des droits des moun qui a un problème dans le travail. Coronavirus, with regard to the times of the coronavirus we're experiencing. I'll do my darndest with the Creole. I hope you understand my Creole.
Luckily, we'll have you. We got your back on that. We'll make sure that we get it. Okay. So I don't know if Sandra or Shirley, y'all want to kick us off with maybe some questions. And for everybody who's watching, I just want you to know que ou gen chance pour poser question pendant l'émission ça. Donc, depuis vous regardez nous sur Facebook Live là, ou après en bas, sous comment sur poser question et dans dernière partie show nous allons poser Maître Anthony toute question que vous gagnez. So feel free to ask questions. We want to make sure that this information is extremely useful for you.
Okay.
I'll kick it off. My first question is, in the days of coronavirus, so we're realizing that well over 16 million people are unemployed. What are you seeing as it relates to employment, as it relates to people who, I know there are words that are being used interchangeably, laid off, furloughed. What's the difference? I think that's a good place to start because many people are told they're laid off, then some people are told they're furloughed, but no communauté pas noire. Pour nous pas réellement une différence ou juste pas de travail, right? That's how we kind of
working.
income. So if you can kind of break that down, at least so that we can start the conversation, so we're all having the same conversation.
Well, just so you're aware, we're laughing, we're smiling, but this is a serious matter in serious times. A lot of people are dramatically and adversely affected by this whole circumstances, both health-wise, socially, economically. Now, with regard to the labor and employment aspect of things, you find where there's a lot of these terms being put out there, furloughed, laid off, but like you said, it's actually separated from the employer. You're not working, you don't punch your clock, you're not getting paid. And interestingly enough, the powers that be, our governments, both state and federal, have taken this into consideration and have in fact taken the proper steps to pass certain legislation to ensure people get paid. Unfortunately, the system, and I'm not being critical on a broken system, I'm just answering your question. The system prior to the coronavirus, with regard to someone who got fired, if they applied for unemployment, they'd simply submit a process and they get a check. The system is antiquated. The system is not working properly. You have a number of people who are applying for unemployment in normal circumstances would have received a check by now, but they're not because the system is shut down, broken down, not processing properly. So we're encountering a number of intakes with regard to that. We're also finding that people are being separated and terminated, laid off, furloughed under circumstances that are not proper in the face of the law. Either they're being harassed, discriminated, retaliated against, or employers are taking this as an opportunity to quote unquote clean house. Dans la communauté haïtienne, nous c'est dernier qui joue travail là, mais nous c'est premier qui a provoqué.
Right.
Et puis ça ne se fait pas. Jouette c'est jouette, couchez pas là-dedans. That's what I've heard and understood. And with that said, ça veut dire que l'on relève à Georges-Pierre pour consultation gratis sur un cas de yo évoqué, yo pas payé autant et demi overtime avant coronavirus, pendant coronavirus, après coronavirus. We check and assess a full spectrum as to what your legal rights under the law are. You have the Family Medical Leave Act, you have the Age Discrimination Act, you have the 42 U.S.C. 1981 with regard to race discrimination. So you have a number of labor employment laws that are still in effect today and apply throughout the coronavirus. A number of things you find is that a lot of these employers are violating the sick pay leave acts that are in play. So I don't want to run too far ahead, so I apologize. Cut me off at any point. And I tend to get passionate when it comes to labor and employment representing my clients.
We can tell.
Okay, so as you can imagine, though I'm born and bred New Yorker, sous coupé m'se rouge blé. So I'm true Haitian. Coupé tête brûlée caille. So understand that with regard to my people, when they come to me and they tell me I've been wronged, I may not have a machete, but I will take that lawsuit and file it.
Amen.
Did you just say amen?
I sure did.
Yes, he did.
We're having church here.
Nou pa gen ase moun kap batay pou nou nan san sa, you know, and I think that all the time, especially in the fields in which we're working, I think we see on the ground ki problem, ki jan komunote pa nou ap soufri. And so it's important to have people like this on our side to know that gon moun ki soti nan mem peyi avek nou, ki kèl pou nou, right? And to make sure that we are not taken advantage of in that sense. Sandra?
Yeah, I mean, I think in terms of, I actually want to go back to Shirley's question about furlough and being laid off. I don't know what just happened. Being furloughed and laid off. Like, what's the difference between those two terms, and how can our community make sense of that?
Well, long and short of it is, they're no longer employed. They're no longer gainfully employed. They do not have a job to go to in the next day. They don't know where the next 2-week paycheck that they were accustomed to comes from. If you realize and understand that our community, they didn't come here to the United States because our beaches aren't pretty like the beaches in Miami. Far from it. Haiti is a paradise, okay? They came here for economic opportunity that did not exist there. So they have family here that depend on the check. They have family there that are dependent on the check. Ça veut dire que les yo pas joindre travail yo ici pour voyer chèque by intel lakay, gon problème ici, gon problème l'autre bord. Now, with that said, the boss lan di yo ou furloughed, ou lay off. C'est révoqué yo, ou pas gen travail. Yo promet ou si gen business qui existe après coronavirus, n'a promet ou après tourner. Mais si yo appliqué pour tout loan ça qu'il y a bay, the $2 trillion cob qu'il y a bay compagnie, et yo pas recevoir yo. Guess what? Moun n'a pas yon travail. And in the meantime, presently, you have a number of situations and circumstances where these people need to be gainfully employed. And until the economy is back on its feet, they won't be. So with that said, you have employers who are going to get this relief, who perhaps have already received the relief if they've applied with it. Because this has been a couple of weeks, I think it's about 2 weeks now since the money's been flowing. If I'm not mistaken, certain people have received in their direct deposit $1,200 from the government. And so that some companies are also receiving that. we're finding that when we file lawsuits against companies, charges of discrimination with the Equal Employment Opportunity Commission on behalf of clients who say that they were wrongfully terminated because of their race, national origin, sexual orientation, or religion, pursuant to Title VII or the Florida Civil Rights Act, or even a Family Medical Leave Act case on behalf of them, employers tend to tell us, because of the coronavirus, we can't afford to pay. Okay? But somehow they receive the funds.
Right. And those funds are supposed to be used to be able to keep their workforce, right? So c'est
correct.
Comme ça que y a besoin de mes gouvernements, c'est pour qu'il y ait bien moun k'ap travail pour yo, right? But they're saying that they're not.
But then what happens to the people who had already laid their people off? Because there's a misconception too que comme malgré la vini en retard, on sait de moun qui te gen temps lay their folks off 2-3 weeks prior to this being voted upon, right? And becoming law. Gan pile moun ki pense, moi même gen job toujours parce que yo bay compagnie un cob pour le kembem. Does that person still have a job?
Unfortunately, the way the Families First Coronavirus Response Act, which is the act that's been passed just recently in March, the way it reads, it went into effect in April 1st. And so anybody who was let go prior to, you're SOL, as they say. Ushire. Did I say that right?
Yeah.
Yeah.
You understood.
Yeah.
So that's where a lot of the calls we're receiving from individuals who either were let go and they're asking for clarification as to what their rights are under these circumstances. They're thinking that, look, I'm reluctant to go forward because I know the employer applied for this law came out, but you were laid off prior to it. Okay, and it's not clear as of today if it's retroactive. What is clear, however, is that the employer is going to be given some short-term sustenance through these funds, but then they've already laid off. And the people they haven't laid off, they're technically protected if all the right steps are taken. You understand? Because now what we haven't heard a lot about is, in addition to all this influx of monies coming in to keep folks on payroll perhaps, is that companies are going to get to a point where if this doesn't resolve fairly soon, within 90 days, for instance, or within 6 months at the longest, you're going to have an increase in bankruptcy. Okay, and a number of people who are wrongfully terminated who would have had viable causes of actions prior to, it gets extinguished. One of the few areas of law that I find that we specialize and concentrate in is under the Fair Labor Standards Act, where the person who works more than 40 hours a week and not paid time and a half overtime, you find yourself where that's one of the safe, protected areas that they can't extinguish under bankruptcy. However, that simply addresses the FLSA, the Fair Labor Standards Act, addresses minimum wage as well as overtime. So if they're not paying you the requisite minimum wage, you have a cause of action. Or if they're paying you the minimum wage, but when you work more than 40 hours a week, they're not paying you time and a half overtime, you have a viable cause of action. Now, if they're letting you go because they're saying that you do not have either sick leave at your disposal, or no, you have to come to work. The fact that your child is at home without daycare or school, and you can't be at home to take care of them, you must come to work. They're violating the current state of the law. They have a cause of action. Okay, and so with that said, the reality of the matter is, folks cannot just simply take it at face value or word of mouth of what the employer is saying. They should seek legal counsel and find out what their due and owing rights are.
And what cases are you saying? Because I think there are people who let's think about some small businesses. There are people who actually have to terminate their employees because the numbers just don't make sense.
So, for example, Sandra, are you talking about a restaurant or something in our community, for example? Would that be a good example? Okay. Right.
So restaurants. So in those cases, I guess we want to get really clear on when do folks, and I know you can't give every example and when folks may potentially have a case, but what are you talking about? I know you talked about when people are not paid in terms of time and a half, if they're working overtime and they're not getting that. I know some folks they may work 40 hours and people only pay them 35 hours. I've heard a lot of that happening in Miami. What other cases do you, that comes across your desk?
Well, in light of the new recent legislation, and let me read them out to you because they're so new that it's still on paper. Okay, it's like the Families First Coronavirus Response Act. Mm-hmm. Within that, you have the Family Medical Leave Act that has expanded and has exceptions prior, but now they allow for folks and companies that are smaller to qualify under that to provide sick leave, sick pay days leave to their employees. So you have small companies who before had no choice. Those circumstances, if they're going to be receiving these funds, they now have a choice. They must make the right choice and actually protect their employees. Now, if ultimately they disappear, they evaporate, that they, no matter what, don't qualify, cannot sustain the status quo, unfortunately, there's very limited you can do. Right. But there are, and one of the reasons I mentioned that particular wage claim is because I find, and I've been doing this for over a decade at this point, that's one of the few areas of law with regard to employee rights that it's almost like a hot knife through butter. Okay, it's one of the oldest employment laws on the books. It's part of the New Deal laws, and you name the personnel, they fall into that mischaracterized, misclassified employee, and they tend to have protections. Mm-hmm. Either even if they fall into an exception route, if they're retaliated against, and again, the Family Medical Leave Act provides for retaliation protection. Florida Whistleblower Act provides for protections. There are a number of laws on the books, both state and federal, that are there. So this state of affairs that we find ourselves in, where a company, be it has 500 employees or less than 500 employees, but they're receiving these funds, the strict intent of the fund is to keep your folks gainfully employed. So if they've let them go, but they got the funds, they need to act post haste and bring these folks back. Comme dit ça en créole. Ça veut dire que d'après Jean loi écrit, nouveau loi, si vous recevoir cob, et pour garantir que moun yo que ou te lay off ou te faire l'eau, ou faire tourner la même. Si pas la même, les yo ka al dehors, parce que qu'on y a gen l'autre qui dit que chita la caillou. So si wap chita la caillou, ou pas qu'à faire travail la caillou, parce que gen pile moun, c'est pas avocat, c'est qui ka travail n'importe côté. C'est yo travaille dans restaurant, yo travaille dans hôtel, yo travaille pour avion. Bay ça yo pas gen business le dia. Mais les bay yo retourner a bon travail pour yo. OK? Et si pas gagné, gon lawsuit captain yo. Mais en pire, moun ka prele nou konya, y a prele pour conseil pour ça ka pou passer plus tard demain, mais là nous fait analyse nous checker regarder oui, demain et jodi a. Yeah. Mais ça yo te fait aujourd'hui oui. Mais ça yo te fait hier oui. Et on a ça yo the statute of limitations tant que ou ken doit faire demande. You know.
I have a question in terms of my understanding of the new act really is about whether or not the loan will become a grant or remain a loan. So there's stuff, I was on a webinar and I guess my understanding.
So you're talking about the PPP.
That's the money from the government.
Right. And that becomes a grant if used properly.
And used properly means that you keep the number of FTEs, full-time employees, at the number it was pre-COVID.
Right.
If that number does not remain the same, then it will not turn into a grant. I mean, you can use it for full FTEs, you can use it for utilities, mortgage, rent. If it's not used properly in that way, then it will not turn into a grant. It will turn into a loan. So folks who
at about 4.25% interest rate, so which is still kind of fairly competitive market-wise.
Right. So for organizations who, let's say, decrease their number of full-time employees, but is the case that they got this money, but they don't do that, so it just becomes a loan. Is that still a sticking point?
You know, the way I understand it, and remember, this is fairly new. Everyone's first experiencing it. At the bottom of the line, it says at risk of perjury.
Right.
Okay. They don't want you to be misrepresenting.
So
application fédérale liée.
Ça veut dire fédéral veut dire y a déporté nous les by menti sur l'application ça yo.
Justement. Et son citoyen américain y a mis
They still gonna deport you.
Mais songez oui, get quelques moun pas noirs qui pensaient que y a poil pour des pères pour cacher à quoi blanc. Je vais coucher par là-dedans. Y a bien là-dedans.
Okay, so I have, oh, you had a question?
I do. I had several burning questions, but Sandra's over here trying to get her union credit. So, une question que me gagne, c'est pour essayer de clarifier pour mon yo, ça a déjà dit, right? So one of the things is that furlough, laid off, you know, relieved of your duties.
You ain't got no job.
Justement,
ou pas un job.
Whatever ça ou pas travail. So you're saying that if that government or so if the government gives them this money, they cannot just use coronavirus as an excuse to just fire you because they've received money to actually keep you, right?
Correct.
And then, so let's say that an entity doesn't receive any funding, right? Can they use this as an opportunity to fire you and not bring you back to the job? So I look at it like maybe, you know, hotels can't keep FTEs now because nobody's really traveling like that to come here. So in that sense, do they have a duty to call back their former employees? So if you were doing housekeeping, if you were working in the kitchen, do they have a duty to call back those individuals who were in that same position and give them like the first right of refusal? Or are they at liberty to, because of the coronavirus, now that business comes back, they're allowed to go out and hire new people and use that as an excuse to fire somebody that they maybe didn't like anyways?
Well, very good question. Here's what we're likely to encounter. Okay, first off is this. You have folks who are working in the state of Florida, and the state of Florida is an at-will employment state. Mm-hmm. What that basically means is that you work at your will, they retain you at their will. Right. You can leave at your will, they can terminate you at their will. Mm-hmm. However, it cannot be for a discriminatory reason. Right. It can't be because of your race, national origin, sexual orientation, anything along those lines. If you fall into a protected class, if you're over the age of 40, they can't fire you, let you go because of age discrimination laws that apply. Mm-hmm. So now you're going to find where they're going to do a pretext and say, it isn't because of this, and it isn't because of this where you're from, it's because of this, the coronavirus.
I like that part.
You understand? So with that said, the at-will employment part of this category, if you're not subject to a collective bargaining agreement, okay, through a union, if you're not subject to an employment contract, and keep in mind, some employers tend to copy, cut, and paste their employee handbook, and as such, unbeknownst to them, create an employment agreement with the employee.
Yeah.
Okay. Now, if they make that misstep, you have a breach of contract, obviously.
Mm-hmm. Right.
Now, do they have a duty to bring you back? No.
Mm-hmm.
Okay. Do they have a duty for right of first refusal? No. What they do, however, if they're smart business folks, is the time and money that they're going to spend to train someone new, they're just going to more than likely reach out to the long-standing employee who started off very young with them and grew with them, and they'll probably invite them back. Mm-hmm. That's what we anticipate is going to happen. That's what we hope will happen. Mm-hmm. However, that's not always the case.
Right.
Many times. I'm sorry. Go ahead.
No, I want to jump on that because I like that point right there. And I want to follow up on V's point because so Miami and predominantly our people, so they are employed in the hotel, the cruise industry, the hotel, that whole hospitality that makes Miami what it is, right? Now, the law says that they're supposed to bring their people back. And part of what I've been hearing from a lot of our people in the community, you'll get back, you'll pay. And majority of the people that they're bringing back they're picking a group of folks to bring back. And then there's another group, majorité haïtienne, that are not being brought back. Right. Just for clarity, is there some form, is that fair? Is it legal? All that good stuff. I'd really like for you to address that because I'm hearing it more and more. So I really want us to address that so that we understand in this Corona time that there are things that are still not fair, they're illegal, and if they are, what recourse do the people in the community have?
Well, very good question. What I tend to find, and like I said, Reamer and Georges-Pierre has been doing this on behalf of employees, Haitians in particular, for such a long time, that we've encountered so many instances where they say, it's not fair. It's not fair. It doesn't necessarily mean you have a viable cause of action.
Right.
Yes.
It still be legal. Yeah. You got sophisticated employers, institutionalized racism, discrimination. Right. It's set up in such a way and structured where the burden of proof is so high that you better document, you better have your witnesses on point, you better be prepared to swear and attest to tell the whole truth but nothing but the truth, so help you. Therefore, you got to have yourself in a position where, quite frankly, you want to ensure that you get to us within the requisite time period. Because
what is that time period?
Okay, within a year. Less than a year, certain causes of action are extinguished. It's like expired milk. Don't drink it. It's going to do you harm. Okay? Si vous parlez Reamer Georges-Pierre rapidement, tout done, pas de problème. Parce que we got to do a charge of discrimination in under a year for Title VII, for the Florida Civil Rights Act. However, if your claiming is yo retourné tout nèg américain, mais haïtien américain yo pas retourné, et puis c'est en 2 ans vous venez pas dans office ouais, vous chirez, pas qu'à aider. Mais parce que we do cases on contingency, meaning that there's no cost, no fee if there's no recovery. We advance the cost of litigation, and therefore I tell folks, I'm in the David and the David Goliath fight. I can't afford to lose. Right. Because if I lose, that means that my client didn't get paid. If my client didn't get paid, I don't get paid.
Right.
So we make sure that we're able to file viable causes of action that, in fact, when you say they brought back all the Hispanics, all the white people, all the African Americans, but because I'm Haitian American, they didn't bring me back, and we're able to establish proof positive, the prima facie elements of a true national origin discrimination claim, we file a charge of discrimination with the Equal Employment Opportunity Commission, the EEOC, or the Miami-Dade Commission, or within certain time periods, we file that, the investigation's conducted, we get what's called a right to sue. If it says it's a probable cause finding, we can proceed. Mais si e ka, outan, gon lot loi m'kon servi avec. It's called 42 U.S.C. 1981, qui dit, parce que de couleur, m'gè 4 ans, m'ka fait un lawsuit, sans pas besoin à nan EEOC.
So let's talk about that really quickly. Haïtien men qui avait tout papier, tout champagne, they hoard everything, right? But you know like you buy jump kebe, what?
Et nous remè kebe moun nan kè.
Really?
You know bagay que nous pas j'aime Québec, c'est un journal de ça qui est passé notre travail là, à ce qui s'agit avec boss nous, right? So that's the one thing nous pas j'aime Québec. Nous toujours penser, OK, bon Dieu a servi avec you, whatever. But si get comme sous table pour à cause de gens après maintenant, I'm going to keep notes. And you know bagay que parce que communauté nous pas tellement fait un pile, c'est Québec note pour dire que OK, notre date ça, boss là femme vini dans office li sans pas besoin rien et puis moi ouais que la garde il va garde figure non la BCG la peut regarder dans côté monde pas supposé garder l'autre semaine après il relève dans office li et puis kounya la mayem whatever Kounya, rive, anti sa te komanse en janvier, now we're in March, Corona, m'pa jam balbo, et puis Kounya li dim, you know what, we don't want you here anymore. I mean, I'm not an attorney in this field, but I think that there could be a cause of action, right? So if we can say that it's because of it's retaliation based on sexual harassment.
Well, here's one thing. Let me interrupt here. Here's what you're right. Our folks tend to take good notes. However, in addition to that, what's very, very important is that they follow the notification requirements detailed in the employee handbook.
Okay.
Yes.
Many people, they've been with the company maybe 5 years. They remember receiving it. They have it somewhere. They just sign on the dotted line. They fill out the I-9 forms, the pre-employment paperwork, and then they get some copies. But also keep in mind too is this, what a lot of employers tend to do nowadays in this era of technology, they do it electronically. So many times they don't have the hard copy, but they do have access to it. So the moment they encounter that situation that you described of the sexual harassment, or they feel uneasy, the hands are being placed on you, they need to look at what their rights are. They need to object to it. They need to tell and report it to human resources. It's the belt and suspenders methodology in these circumstances, where you have not only you verbalizing it, you need to document it and send it through and have confirmation that they got it. An email, a fax. Because you make my life and my job difficult when all you can say is, it was me and him only in the room. It becomes a he say, she say.
Yeah.
Understand? They're not going to parade 50 people from 20 years ago like they did for Bill Cosby on your behalf. That's not what's going to happen. So
but what if you work in a mom and pop who's not giving you an employee handbook, and the owner is HR and, you know, every level of senior leadership? So what do you do in that case?
Well, if it's just you and the owner, you're going to have a tough time, but we'll take the case. We'll prosecute the case. It's going to be an uphill battle, but we're troopers. We're warriors. We'll carry that pack to the top.
You know, so I do have some questions rolling in, and ladies, you can feel free to jump in as we go. So the first one is our homegirl Denick, who's also a nurse. So shout outs to Denick.
And on my board of directors. Hey, Denick.
Yes. Is there a situation where an employee will receive back pay if hired back?
That's a very good question. Because it's so fairly new, that hasn't been determined yet. The present state of the law hasn't fully and adequately addressed that. More than likely, you get paid. If you're on salary, for instance, they let you go. So you weren't working. So they're not obligated to pay you anything that's not there. Now, if you're sent home and you're salaried, technically speaking, you should be getting paid.
Yeah.
If you punch a clock, typically, under normal circumstances to do work, and you punch the clock and you're sitting at home because they're telling you punch the clock and we'll keep you communicated, they're supposed to pay you. But if you're at home not punching the clock, they don't owe you.
So that means when you get hired back, you're going to get the money from the date of hire, the start date to, you know, until termination, but you cannot collect on time that was not spent working.
Here's one thing that's likely to happen is that you're going to find unsavory employers taking advantage of the situation, where if they felt yesterday Vanessa was getting paid way too much.
Which is not the case. That's
Come
not
on.
Anywhere, not the case.
They're going to bring you back.
Ask your cousin, Anthony. That's not the case. Ask your cousin.
Well,
you're saving the world, so it's acceptable.
I was going to ask, I mean, I think we haven't necessarily talked a lot about health professionals who are on the front lines, who are not being protected by their employers.
Or paid enough.
Or so, for instance, some of them are getting hazard pay depending on the organization that they work for. So you can be a nurse, get hazard pay at one hospital, and some nurses not getting hazard paid at other, or or organizations who are really risking your life because you have to wear one mask for the entire week because you can't get another mask for the next week. You know, what about those kinds of issues that employees may be facing?
Okay, so that's where, before the coronavirus, there's a law that's typically known as OSHA, which is the Occupational Safety Health Act. Okay, and basically what OSHA provides for is regard to that, to ensure that the workplace is safe, including providing the necessary protective equipment to ensure that the first responders can be out there to do what they trained and are capable and able to do.
Mm-hmm.
Now, if you find yourself in a situation where you stated to your employer, these masks are supposed to be disposable, and because there's all of a sudden a lack of masks and you're recycling and there's not enough distance with folks, or that it's hazardous environment, and after you're terminated, you got a retaliatory discharge claim. You have a right to a claim. To answer specifically your question as to the hazard pay, if hospital A is giving it and hospital B is not giving it, you know, they don't have to follow the same trend.
Right.
One hospital, one employer tends to look out more for their employee versus another.
Right.
You know, when things normalize, and we pray very soon, maybe that person considers going to hospital B.
Yeah.
Okay.
I just want to come back to that point. I think for a lot of nurses, at least folks that I've talked to, they are experiencing that. I know people who are like, I'm going to make a decision because I'm going to put my family in jeopardy because my facility is not taking the proper precautions. And so I think in our community, we all like issues about a child, but there are serious things that we, go see an attorney because your organization, who's supposed to follow these OSHA laws, regulations, aren't doing so. So, hospitals know OSHA. Yeah, that's my background.
They don't even have that sign in the office, anywhere in the office.
OSHA.
It's interesting. It's interesting you said that about the sign, because a lot of these folks, even if they're for whatever reason can't get to call us or any other lawyer for that matter, they're supposed to be posted. Yeah. These signs are supposed to be posted.
You can call OSHA.
It's supposed to be posted so you know what your rights are.
Yeah.
The wage law is supposed to be posted. There's that picture of the lady with the broken arm for the workers' compensation, which, by the way, we haven't even addressed that. In this time and age right now, you have that experience. If folks catch the coronavirus stemming from being in the workplace, the state of affairs of workers' compensation will cover you.
Oh!
So that was going to be my question, right? Whether you work in hospitals, and I know I'm hearing it a lot from nurses and doctors and, CNAs, because we tend to think that the only people that work in hospitals are nurses and doctors, but the people who allow for them to be as efficient, there's a whole heap of people behind them, right?
Right.
So we want to give a shout out to them as well. But then we have a lot of other people that are frontline employees that I want to ask if they happen to get sick from this virus.
In the workplace.
In the workplace. Well, that's kind of hard because you wouldn't be able to really know how you contracted it. But okay, in the workplace.
But the workplace will tell you, because a lot of workplaces are saying you've been exposed. You've been exposed because of a COVID patient. So then they test you, and it's because.
So I guess my question is: now you've tested positive for the virus. Are you taking your sick leave, annual leave? How are you covered as an employee?
You're covered. You're covered under old law. You're covered under new amended law. You're covered under new current law. The Family First Act, that provides specifically for those circumstances. The first 10 days aren't necessarily compensated, but thereafter you are to be compensated.
What if you're per diem? What if you're not?
I got a question. Now you got us getting technical here.
Now he about to pull out the book.
The big book.
She's good. See, per diem, you're not necessarily a W-2 employee.
Right.
You might be a 1099 independent contractor. Mm-hmm. And that becomes a nuance for a later day.
Are they covered?
Our position would be, Call Reamer and Georges-Pierre.
Are the 1099s covered?
I'm sorry?
Are the 1099s covered as contractors?
Unfortunately, no. But here, let me say this. Understand that there's a misconception between 1099 and W-2. Those are forms.
Mm-hmm.
That doesn't necessarily mean you're not covered.
Right.
There's a number of tests, steps that have to be determined to confirm if you're not in fact an employee. We find a number of people have been receiving 1099s and told that they're independent contractors when in fact
they're employees.
Employees.
Yes.
Yeah.
So
and there's so many cases. So I tell folks is this. I didn't go to Google Law School. I actually went to law school.
Okay? So this was I aced this in contract law. This was my favorite thing because they're like, listen, just because they called you an independent contractor, but they control how you do your job.
Right. And they can supervise you.
That's right.
So they're crossing that line.
The legal term for that is economic realities. This is the reality as to if they control your comings and goings. Where if you're supposed to be independent, that means that you're supposed to be able to go work for employee A, employer B, employer C, and still do work for them. But if the entire time you only can have time to do work for this company, they tell you what to do, how to do it. You have no independent discretion. You have no autonomy. C'est pas independent contracteur qu'on y est.
No. Yeah.
Ou travaille toujours. Ça pas regarder qu'il n'y a pas de tirer taxe.
Yeah.
Ou te faire taxe ou il n'y a pas de droit violer loi. That's plain and simple.
You know, I think I got a client for you. We'll talk about that. So,
I got a clue. Is that referral rewards?
Here, let me tell you this. God is good.
Amen.
And so you send me goodwill, good faith. I send you goodwill, good faith. Unfortunately, if you're not a member of the Florida bar, I can't share my fees.
Oh.
You understand?
Jesus. Okay.
But here, the good service we're providing to the community. This show, for instance, letting folks know in South Florida, in the World Wide Web of their rights, because Reamer and Georges-Pierre, we handle cases nationwide.
Right.
Florida's our base,
but
we are also admitted to federal courts, so we file cases in federal court.
Okay, great. So I have like a lot of questions coming up here.
Listen,
so let's get through a few. Huh?
Go to Lowe's question because that's a good question.
Wait, but I gotta get through everybody else.
Go.
Monique Johnson been waiting for her answer. Okay. So I have a question pertaining to the FFCRA process and the FMLA. I am expecting. She didn't say what, but I'm assuming she's pregnant.
We gonna assume that.
But since she was waiting, however, I am taking advantage of the extended leave due to childcare. I am due in August. Am I entitled to 12 weeks under the FFCRA and 12 weeks through my regular FMLA?
Oh, she's trying to combine them?
Combine them.
Yeah.
Oh, that's going to be tricky. More than likely, if it's not medically necessary, she's not going to get it.
Not going to be, yeah.
Okay.
So however, you see, depending on how you answer that question, I was going to make a baby real quick because I was like, wait, you can combine all this vacation and just take a few months off.
Oh, Vanessa.
You know what? Next question. Don't pay Vanessa no mind. Go ahead, Vanessa.
All right. So the next question comes from our friend Amarel Jabba. What about independent contractors who are their own employee? Can they apply for the PPP or the advance?
They can apply for the PPE. PPP.
Yeah.
They can apply for that because they're an employer. Now, understand, they got to go through the certain banks. What banks are doing right now, which is fairly smart on their part, is if you currently have an account with them, they're going to work you through the process. So she probably has a banker she deals with on a regular, consistent basis under normal circumstances. And so because it's so new, they're not quite certain exactly who's qualified and who's not qualified. And then one thing too is this, in addition to the PPP, there's these other grants. She may not necessarily qualify for this, but she might qualify for some of these other grants that they're offering through the same umbrella package. The SBA, to their credit, is giving a lot of funds out. Taking a long time,
right?
Giving a lot of funds out. And one of the things too, they got to be careful of. My understanding is if you apply for the other before you do the PPP, you may preclude yourself from some funds.
Yeah.
Okay.
Wait, I have like just a commentary.
Lo is going in on us. I don't know if she's asking questions or just making commentary. La fête basse. That's what she's doing.
You know how people call in. This is like the new way to call in, y'all. Or you say bonjour.
Look. Let me tell you what Lo says. So I don't even know Lo. I don't know. Is Lo your friend, Sandra?
I don't. Lo may be her nickname. I'm not sure.
Okay, so Lo is funny. She goes, another issue. You're temporarily furloughed, but the company is asking you to send a check to cover your medical insurance. At least they should cover that. And then she put the So let's see.
But wait.
Monique Johnson.
By the way,
she's expecting a baby. Congratulations, Monique Johnson.
But by the way, something to take into consideration: folks who've been terminated, COE Bokeo, they have a certain number of days to comply with COBRA requirements, where they're supposed to notify you as to how to continue coverage. COBRA is expensive, but still they're obligated, depending on the size of the company and the entity, to provide you notification within a certain number of days. If they fail to do so, you have a viable cause of action.
Okay.
And even if they do so, call me, because if it's not done properly, we got a case.
He's reminding you. For everybody who's watching, we do have Anthony's information actually pinned down there in our comment section. So feel free to reach out to him, call his office. The email is there, the phone number is there, his name is there, the website is there, everything is there. So, going back, thinking about the folks who are most affected by this, where do kids come into play, right? So I know that there's a lot of kids who, the kids are not signing on to they're not logging into their little dayschools.net or school portals to be doing homework from home, and they're actually going to work.
Well,
so do kids have the same rights as an adult would have in terms of all of these protections that we're talking about?
Well, see, when you make reference to kids, keep in mind is that there's a certain age limit where child labor laws come into play.
So how old do you have to be to have a job, and how old, and then just continue the rest of the response.
Well, keep in mind is that you could be a 10-year-old paper boy, and maybe I'm showing my age. Maybe they don't.
I remember that.
Okay, so, or you could be a bag boy at a supermarket where by day you're in class and by night on weekends you're bagging people's groceries and taking it to the car. You're an employee. You're typically more often than not necessarily working the 40 hours a week. You're working less than that, okay? And you may not qualify as a full-time employee, but you do still have rights. There's a minimum wage rights under the Fair Labor Standards Act. All the discrimination laws that exist, both state and federal, you're still protected under that. It has nothing to do with the number of hours. It has to do with the fact that you qualify as an employee.
Right.
That's what it comes down to. So yes, anybody and everybody is technically protected if you meet certain criteria. If first criteria is that in fact there's an employer-employee relationship. That's the first step. Secondly is there in fact a violation of the state and federal law? And even local ordinances too, because Miami-Dade County, for instance, has a number of protected rights that protect employees as well.
So I have a question. So right now, because Beyond the Hour is really more, we've done this more in English. So for our Gen Xers, our millennials, they're listening to us right now, that their parents may be employed in these hotels, the cruises, the restaurants, whatnot. normally, because many of these parents are not going to be the ones to pick up like Sandra likes to call them, Timami Tipapio, are not going to be the one to pick up the phone and call Anthony, right? So they're going to talk to toutes celles dans l'église là avant, and then eventually, okay, they're going to talk to all of them before they actually have a conversation. So my question to you is, what advice would you be giving us who are going to be the ones that would make the phone call? When is it advisable for us to say, okay, you know what, Mom? Instead of listening to all these people, let's pick up the phone and let's call Anthony. Because I think there's a lot that's going to be going on that our community, one, is going to feel lost, two, feel overwhelmed, or just feel as though, because we just have the spirit of it's always us, right? Yeah. They wronged us. It's not fair. I just have to deal with it. How do we remedy some of that by simply empowering the children who they will be turning to?
Right. Pick up the phone. Take the first step on behalf of the mom and dad. For instance, when mom and dad were told, Chita la caille, parle dehors, ou ka mouri. Guess who told them, Chita la caille, parle dehors, ou ka mouri? And then they locked them in. Same fashion, you pick up the phone and say, est-ce qu'on capable avec avocat Anthony Georges-Pierre du cabinet Limerick Georges-Pierre? 305-416-5000.
Nice plug.
Okay. Gotta do it. If they're reluctant, if they gotta talk to Pastor that's fine. Let them have that conversation. But you, in the meantime, cabrit fait petit pour aider au protège.
Come on.
It's bourrique fait petit pour aider.
Okay.
I got it.
But I understood you anyway. I got it.
You got me. So while they're sitting having conversation, letting the statute of limitation tick away, letting their rights dwindle down, flow down river, you all take the proactive step and call and ask the question. You all get us online, because right now our offices are open, but not to meet nobody. We're doing everything teleconferencing, Zoom, telephone, everything electronically. We got the contract signed. We make it so simple that the only thing that becomes difficult is convincing you to pick up the phone and call.
Right.
The consultation is free, so it doesn't cost anything for a conversation. But mind you, I respect your time, so I'm going to respect my time. If you're on the line with me wasting my time, I'm going to tell you you're wasting my time. You don't want to do something. You like getting abused. You like being discriminated against. You like being broke. I'm trying to get you paid, and you playing games. Okay? Et puis, m'a dit carrément, blanc gain avocat parle.
Yeah.
It's very simple. And I used to tell people this: if you're in South Florida and you never heard of Reamer and Georges-Pierre, it's because you just got here, or you're one of the young millennials.
Because I hear about you on the radio all the time.
Yeah, and I don't even pay for the ad. So what does that tell you? that tells you your boy ain't washed day in Mongol mood, and they also know that we're making it happen.
We got all the proverbs tonight.
All the proverbs, girl. All.
Understand this. My dad is a published author, historian in his retirement. And I got that Haitian blood. Like I said, I'm a New Yorker born and bred, but coupé c'est rouge et bleu. I was raised on Haitian proverbs. My Milan sauce pois en sauce de moxeli.
So we have about 3 minutes to 8 o'clock, but I mean, if everybody's in agreement, maybe we could do an extra 10, 15 minutes max. I want to read a comment from Jeff, and I want to ask you a question after that. So Jeff Lozama.
Hi, Uncle Jeff.
Hi, Uncle Jeff.
Says, ça, Anthony a raconté là, a posé que tout business haïtien fermé à soya là parce que tout business yo en violation,
Well, before you say anything else, let me say this, and I apologize for interrupting you.
No worries.
If you are a Haitian business owner, sous son maître compagnie, et ou pas sûr soit fait bail bien, nous caillons tout.
Great.
Because quite frankly, I would rather you do it right and help you prosper versus you do it wrong and then your employee becomes my client and I take you under.
Right.
Come to me so I can get you to do it the right way. One, get you continuing getting paid and growing. Two, keeping your employees gainfully employed and being done right. And you're growing and expanding. You got some companies. Puis ça, juif yo vini, yo gen ti compagnie, demain yo gen franchise. Puis ça, haïtien pas qu'à faire ça.
Right.
They can. Man, you're besoin alwe avocat qui gen cheveux yo cap blow in the wind. Yo, you know, we can make it happen too in our own.
Right. Absolutely.
So what about, I have two kind of related questions. One is for folks with non-traditional employment who are probably considered independent contractors. So people who sell non-pharmaceutical medication.
Listen.
Are you talking about curbside pharmacists?
Huh?
Are you talking about curbside pharmacists?
Yes.
Like Kilos
they're doing
Incorporated?
good.
Yes.
They're doing good.
So, you know, those folks, and then kind of, you know, and then also for folks who are working under the table, what rights do those folks have?
Okay, let me put it in this fashion. Not necessarily how they generate their money.
Mm-hmm.
The fact that maybe they're undocumented. Yo pa gen papier, yo illegal, yo sous TPS a expiré, yo sous deportation, mais a travail en batable. They still have rights.
Oh, that part.
They still have rights.
See, the United States of America.
Right. Now, here's where it becomes tricky. For instance, if you are working for an employer and you use the fake Social Security card number and you get hurt on the job, you may be disqualified because of that act under the workers' compensation. But on the flip side, you got these employers who know you're undocumented. They don't ask for the number. They allow you to work. You get hurt on the job, you're protected. Now, the downside is, in terms of the dollars you're going to get, you're only eligible for the medical treatment and recovery.
Okay.
Mais songez, plus qu'on fait pour vous, plus qu'on fait pour tête moins.
Yeah.
So, relève pour consultation gratis. We'll take care of it.
So, you know, if we want to ask some final questions, and of course, I want to, you know, thank you for this valuable information. I'm going to not feel because the conversation, we found a way to make it entertaining, but bagay sa yo très sérieux et l'important que nous prenions tête nous pour nous forcer moun respecter droit que nous gagnons, especially when it comes to the workplace, because we're often taken advantage of because we don't know, we don't trust, and of course we have a community full of folks who we're looking towards for information who are not able to give us the correct information. So I just want to remind everybody the importance of what is being said here. Shirley, you were going to ask the question?
Yeah, I think the final question that I want to ask, so since this whole conversation really came about because of what we're going through right now, this pandemic, as a parting for me, what do we tell our employees that are on the front line? What do we tell them as employees? What are your rights? Something that they can remember, something that they can, I know we talked about a lot, but these people are living it. They're fearful. They're going to work. Some people don't have the choice of not going. How are they protected? And if they find themselves in a precarious situation, what do they do?
Very good question. First and foremost, the ultimate wealth is your health. Mm-hmm. Irrespective of that paycheck, if you get sick and die,
mm-hmm.
Come on.
So you need to take
sir. They have a sorry for your loss, and if you work for Publix, they may send your family some refreshments. That's it.
I'm done.
I've had causes of actions against that employer, and you're absolutely correct. I will simply say this, is that the first step is to protect yourself. Your number one priority is to protect yourself. You protect yourself health-wise, taking all the necessary precautions detailed by the CDC. the masks, the gloves, the constant washings, and so forth. If you're required to go to work or you're concerned about your health if you go to work, you need to detail and specify that to your employer. And if they take certain proactive negative steps that result in adverse employment, you have a viable cause of action. You call us. You call us. Okay? If you're not sure.
What's the number they call?
305 416 500 305-416-5000. It's Reamer and Georges-Pierre. We're the only Jewish Haitian American law firm in the state of Florida. We make it happen. God's good and bless us tremendously.
All right.
What was that?
Santa. No, I said that you're not the Jewish one.
No, I'm the Hebrew one.
That part.
Santa, do you have a final question?
I mean, I just think this, I have a final comment. I just think this was super enlightening. I think that when folks are, to Shirley's point, when folks are thinking about the front lines, we may be thinking about the nurses, the doctors, the people in the healthcare industry, but there are folks at the grocery store who have to work, who have no protective gear. They too have OSHA in their staff lounges. There are people who just have to be out and about because of us. I'm also thinking about farm workers who are also making sure that our grocery stores get stocked, who are in desperate situations right now because of COVID. So I just want, to Shirley's point earlier, for us who have parents to make sure that we get our money too, because when they sick, we are then.
Come on.
It's our obligation, it's our issue, it's our responsibility. So just making sure that we are making sure that our parents have this information, and that we also push them to make sure that if there is a case, if their rights are being infringed upon, that we go and help them seek an attorney. If we wait for them, it's just like life insurance. They're not going to do it. We got to do it.
Yeah.
When it doesn't happen,
be careful with that life insurance conversation with Haitian parents. They get scared.
Yeah, what they say 2 years.
But let me say one thing. Understand, everybody drives a car. Everybody knows you got to put oil and change your oil in the car. But not everybody gets underneath the car to change the oil. They take it to Jiffy Lube, to the Goodwill, and get it done. And not saying you can't do it, but why do it when you can have someone who specializes and concentrates on it to do it?
Because if something go wrong, I can be like, Jiffy Lube, Toyota,
Yes.
What happened?
Yes, and it doesn't cost you anything to call me. In my day, you had to put a quarter into the phone. Now that Verizon, T-Mobile, it's a free call. I don't even bother with the 1-800 number because 305-416-5000 nationwide. It works nationwide. Et puis nous parlons créole. Hablamos español. We talk your talk. I'm not a Democrat. I'm not a Republican. I'm a capitalist. I play by the rules to win by the rules. The rules say my client has a cause of action. I'm going to sue. My client is a company owner and doesn't want to get sued. He's going to let me tell him how to do it the right way. We're going to do the right way because the right way gets everybody doing well. The employee, the employer, the community.
So with that said, any final words, Attorney Anthony Georges-Pierre? Thank you. And, thank you again so much. But any final words from you?
Listen, I'm so impressed by your show. You three ladies are extremely impressive. Extremely impressive. This was a thrill for me, a privilege and an honor. If I'm ever afforded the opportunity to come back, rest assured I'll be back.
Thank you. No, we would definitely love to have you back.
and the service you guys are providing, I don't know whose idea this was, but God bless you. This is a tremendous thing. This is tremendous.
We'll talk after the show. But thank you so much. Thank you so much, Anthony Georges-Pierre. Et à tout le monde qui n'a pas de chance de poser question, we did give you numéro mettre là pour relé dans bureau li parce que malheureusement je crois que pasteur pas à l'école pour ça. So I think que si Anthony Georges-Pierre non seulement il a prié avec nous mais la bonne information.
305 416 5000.
24 heures sur 24 heures. 24 hours a day, you're going to get a live person who speaks your language. They'll take your number and will return the call in the morning and have the intake and not a deal.
That's right.
Awesome. So merci encore, Anthony. And thank you again for being our first guest on Beyond the Hour with the VSS Hour. Ma fait tout le monde connaît que semaine prochaine, à même l'heure, sur 22 avril, mercredi 22 avril, at 7 o'clock on April 22nd, we will be having another show. And this time we will be focused on employers. And so, si ou bon business, si ou ap gérer au business, ou se met au business, entrepreneur, tant pis, branchez avec nous mercredi prochain à 7h p.m.
We're going to give Anthony number to the employers too.
So, merci encore une fois. Et n'a remercié Télépam TV, n'a remercié MC Image Productions, n'a remercié Flaco, n'a remercié James pour tout travail, tout effort que vous faites pour porter segment ça ba nous à soir. And thank you so much to the Haitian Lawyers Association and the Haitian American Chamber of Commerce pour le fait que vous êtes nécessaire et extrêmement important, surtout dans temps ça pour porter information ça by communauté nous. So thank you so much. Thank you to everyone who was involved. Encore une fois, non pas moi c'est Vanessa Joseph.
Non pas c'est Shirley Plantin.
Non pas c'est Sandra Denis.
Écoutez au carré là, M. Anthony.
305 416 5000. Now bataille pour.
That's right. So, bye everybody.
Bye everyone.